while presenting legislators with proposals for overdue reforms. I'd love to give you endless background on the qualifications of the speakers tonight, but we would be here till midnight and beyond. And so, without further ado, I'm honored to give you our next speaker, Kenya Rockman.
Thank you, everyone. Thanks for hosting this, Leon, and thanks to everybody for coming. I really appreciate being here. And today I want to talk about the fight to end the use of debtor prisons in child support cases. Debtor prison, the use of them is something, or abolishing them is something that's dear to my heart. So I've written a bill that we're trying to get passed up in Texas and hopefully nationally. So that's what I want to talk about. There's a great national concern about separating children from their parents at the southern border. And there should be, as there is such extreme trauma with separating children from their parents. That same issue of separation should also be a concern when parents are separated from their children in cases of parental alienation, custody disputes, and family court abuses. Arguably, one of the most unconstitutional acts executed by the family court system involves the child support system and the use of debtor prisons when parents allegedly owe child support debt that they cannot afford to pay. Before I discuss the unconstitutionality of the use of debtor prisons, I want to mention a few fathers who have lost their lives because they have become involved in the child support system. Felix Manis of Erie, Pennsylvania was a 48-year-old father and was sentenced May 4th in 2018 to the Erie County Jail. He was accused of failing to pay $750 in child support debt. When Manis was on a work detail, he suffered an asthma attack, and officers allegedly failed to call the paramedics. Manis died on June 11, 2018. Walter Scott of North Charleston, South Carolina was a 50-year-old father of 4 honorably discharged from the U.S. Coast Guard. He was pulled over in 2015 by a police officer due to a reportedly faulty brake light. Scott ran during the stop, according to his family attorney, due to child support and a fear of maybe going back to jail. At the time of his death, Scott allegedly owed $18,000 in back child support payments and had been jailed previously for owing child support. Scott was shot in the back by the officer and died from his gunshot wound. Thomas Duhenny of Barrington, Illinois, was a 51-year-old father of 4 and who had been a successful businessman. He was being held at the McHenry County Jail sentenced in November of 2017 because the judge ruled that he repeatedly failed to pay fines and fees in a recent divorce. He had tried several times to get the fees reduced due to a significant reduction in his salary. Over the course of 3 years, he had been found in contempt of court 4 different times. On the final arrest, the judge ruled that he was being held due to the noncompliance and inability to pay $125,000, which included child support debt. On November 17, 2017, officers found Duhenny in his jail cell dead from an apparent suicide. All 3 fathers share one commonality: they had all at one time been held in a debtor prison. There are many other tragedies that occur when parents are incarcerated due to allegedly owing child support debt. It is critical in this fight against these illegal arrests that we educate the public and the legislators as to why this particular child support enforcement tactic violates the Constitution. Jailing parents for contempt of court due to inability to pay specifically undermines the Supreme Court decision of 2011 when it ruled on the Turner versus Rogers case. The case involved a low-income father who had been jailed several times over a course of years and held in contempt of court 5 times for failure to pay child support. The High Court ruled that Turner's right to due process had been violated based on his not having an attorney, even though the civil proceedings could result in his incarceration. The SCOTUS did hold that the states does not have to provide counsel to an unrepresented non-custodial parent. However, the state must have, and I quote, in place procedures that assure a fundamentally fair determination of the critical incarceration-related question whether the supporting parent is able to comply with the court order. The Supreme Court held that courts violate due process when it finds a parent in contempt and jails a parent for failure to pay child support without first inquiring into the parent's ability to pay. You'll hear ability to pay many times because it's critical to due process in child support cases. A judge must not impose punishment in a civil contempt proceeding when it is clearly established that the non-custodial parent is unable to comply with the child support order. The Supreme Court was clear in describing these safeguards, and yet nearly every state across the nation ignores judges and caseworkers when they do not offer the non-custodial parent an opportunity at a contempt hearing to respond to the statement and questions concerning their financial status. The safeguards, they should require an express finding by the judge that the non-custodial parent has the ability to pay based on the facts in the case, not on assumptions. They must reduce risk of erroneous decision-making with respect to the non-custodial parent's ability to pay, and states should consider whether their contempt proceedings are fundamentally fair. How many people have heard or been in courts and the proceedings were fair? Nearly a decade after these examples of safeguards were identified and shared with state officials, there is no state that has implemented and exclusively follows these rules of safeguarding. States such as Texas, New Jersey, and Michigan, just to name a few, regularly conduct child support roundups where they hunt non-custodial parents with arrest warrants for failure to pay child support. One of the most recent of these arrests occurred in Longview, Texas, where 22 parents were arrested on civil warrants and faced up to 6 months in jail. There was no, nor are there ever, any mention of these parents having a hearing to determine their ability to pay prior to their arrest. By denying parents this option prior to incarceration, Texas and every other state is violating the SCOTUS decision on the parent's right to due process. The states continue to wrongly incarcerate non-custodial parents for child support debt without considering these three key issues in reference to the purge amounts: the parent's actual earnings and income, the substantive needs of the parent, and the child support amount compared to the parent's actual ability to pay written findings. Nowadays, parents can be homeless, disabled, you name it, they don't even look at the actual case. They just go by what the court order says the amount due, and that is wrong, and it's illegal. There's rarely a day that you can turn on the news and due process is not mentioned, and the family court system, specifically the child support system, violates due process in child support agencies and courtrooms every day across the country. Yet instead of citizens voicing concern over these unconstitutional violations, the anger is turned toward other humanitarian crises. Not that there's anything wrong with that. However, if the government promotes, enforces, and profits from a system that regularly separates American parents who are legal citizens from their children without remorse or concern, why would anyone believe that these officials would care about separation of families illegally crossing the border? No matter what answer you come up with, the facts are that the Supreme Court found that Turner's right to due process had been violated several times. It is time to force the states to acknowledge that parents have a right to due process regardless of their financial status. Amen. Make no mistake, states should already practice these guidelines outlined in Turner. Therefore, this should not be a decision of if these rules should be implemented, but why haven't they been implemented already, and when will they be implemented? We know that any bill that focuses on child support reform or shared parenting that's introduced will be controversial. And we know why, because the family court system is a multi-billion-dollar industry. But that should not deter us from fighting and demanding that child support and family court regulations be reformed. By starting with the demand that debtor prisons be abolished, we send a strong message to the opposers of issues like shared parenting and supporters of parental alienation that we are here to fight the serious fight, and we will fight till the end. Yes. Children and equally important parents deserve nothing less from our society, and especially those hired to govern. We must stick together as we continue to fight, because we all know there's power in numbers. Remember, they can ignore one, they can ignore hundreds, but they cannot ignore thousands. Thank you.
John, thank you.
Thank you.
And in all my years of experience as a trial attorney and now a victim, I can validate the things that are being said here. Everybody, the things that are here are so on point. My next guest and speaker is Dr. Anthony Pappas. Dr. Anthony Pappas is a professor of economics and finance at St. John's University in New York City. Among his many credentials is a